Good afternoon. I am Dr. Zoe Spencer, and at the request of lead advocate Candace Lucas and Dr. Marla Crawford, I am serving as their human and civil rights advocate and strategist. In my role, I have combed over many records, which include audio and videotapes, emails, court transcripts, canons, model rules of professional conduct, federal rules on the IDEA, Section 504, and the ADA, Virginia codes, and the Constitution of the United States. So I do not stand here subjectively or advise without reason. Over the last several months, the nation has been faced with addressing the ways in which white citizens have abused this nation's resources to address their fears, stereotypes, and disregard for the constitutional rights and protections of Black and brown people. Be it a Black student sleeping on a sofa at Yale University, Black men waiting for friends at Starbucks, a Black real estate agent inspecting a house, or Black women protecting the federal rights of Black, brown, and poor white children so that they might receive a free and public education. We have reached back into Jim Crow, where institutions use their privilege to summon the police to do nothing more than relieve their discomfort and/or dislike for challenges to racism, discrimination, and privilege in what they deem to be their spaces. The abuse of a system to violate the constitutional protection of Black and brown people post-Jim Crow must be fervently addressed, from the school office to the courthouse. On January 30th, 2018, our parent, who had recently lost her home due to extreme financial hardship and was in the process of looking for another home in Henrico, and her advocates, lead advocate Candace Lucas and Dr. Marla Crawford, went to Colonial Trails Elementary School to take the son and student of the parent, only to find that he had been involuntarily withdrawn from the school under claims of residency issues. When the principal refused to re-enroll the student, the advocates and their parent, believing the removal and failure to re-enroll the student a violation of the student's rights under FATE rules for homeless parents, challenged both the decision and its motivation. We all agree that sometimes challenge can be uncomfortable, but it is always necessary, especially for parents who are faced with having to protect and defend the rights of their children. Yet, when the challenge became simply uncomfortable for the principal and his staff, they demanded that the parents and advocates leave, specifically lead advocate Candace Lucas, under the threat of police action. When the parties refused, stating their bona fide right of claim to be on the premises of CTE, to re-enroll the child, receive records, and challenge the validity of the school's decisions, as promised, the principal summoned the police and threatened the parties with the trespass violation anyway. HCPD, Henrico County Police Department, serves as the enforcer of the law. They arrived on the scene, and as no trespass violation under VA Code 18.2-119 or 18.2-128 had been or was being committed, the principal was faced with the reality that the officers would not be arresting Drs. Crawford, lead advocate Lucas, and the parent today. The officer named in this complaint was at that time cooperative, rational, and expressed to the advocates that he was there to protect everyone's rights, which included the First Amendment rights of the advocates. Certainly, if the advocates had been in violation, HCPD would have been required to effectuate an arrest and remove them from the property. When the advocates informed all that they would return the next morning, the officer informed all parties, including the advocates, that he would return at 8 a.m. to protect their rights. In an email, we learned that he advised the school that there would be problems if they did not re-enroll the student. In another email, we also learned that the superintendent of HCPS, who was aware of the advocate's presence, was working with the chief of police to address the advocate's plan to return the next morning. We must be clear. Our advocates have a long and successful history fighting against the systematic disenfranchisement of Black, brown, and poor white students in Henrico County. And Henrico equally has its own long and successful history of ranking #1 in the nation for the disproportionate disciplinary referral of students of color and the school-to-prison pipeline. So Henrico County Public Schools' issue with the intersection of race, gender, and disability is on the national record. It is not new. On January 31st, 2018, the parents and advocates arrived at CTE as planned and stated, records show that after being invited to sit in the front lobby, Colonial Trails Elementary School principal enacted a lockdown in the presence of HCPD, where there was absolutely no threat and absolutely no disruption to or contact with any of the children outside of the student that they were attempting to enroll. While the lockdown was staged by the school, HCPD stood by and did nothing. At 11:25 a.m., lead advocate Candace Lucas informed the staff and press that they would return daily until the child was re-enrolled in school, his only point of stability during the transition. Then at 12:30, when the school district could not utilize HCPD to effectuate an arrest and have the advocates removed, the principal and his administrator went to the magistrate to swear out a warrant for trespass, citing the school lockdown and other unlawful and erroneous claims like disruption, to ensure that the warrant was issued and a summons was effectuated for each party using the exact same language, no less than 3 minutes apart. Despite their consistent assertions of the bona fide right of claim and their legitimate, lawful, and federally protected business purpose, in addition to the lack of criminal intent, which are all established as affirmative defenses to the enforcement of VA Code 18.2119 and 18.2128, that make both enforcement of trespass violations illegal and unconstitutional, and convictions an error as a matter of law, the parties were blindsided, served with a summons, obtained under false pretense that they did not know was coming, forced to stand for a hearing before a not-so-impartial court, and convicted anyway. The judgment, which is under appeal, included a lifelong ban from HCPS's property, its employees, and students. Transcripts prove that even when our lead advocate asked, "What if we have children on the school property?" the court replied, without question, "You forfeit that right," thus underscoring and reaffirming their initial bona fide right of claim. We corralled this moment to officially state that we challenge the intent, process, and the constitutionality of all acts, processes, and judicial decisions that have led to this moment. Understand that we are refusing to be pushed back into what Michelle Alexander terms the new Jim Crow, where Black women are not given the right to be included and protected under the 1st, 4th, 5th, and 14th Amendments of the U.S. Constitution. Thus, we will wage overbreadth challenges to any policies or laws that may be misinterpreted to simply extend their purpose to do nothing more than silence grievance and curtail the advocacy not of 2 tornadoes going down the hallways, causing disruption everywhere they went, but rather just 2 parent advocates who would dare challenge the continued disenfranchisement of a little Black boy in Henrico County Public Schools. This is just the first step in the long stairwell that we are prepared to climb in order to ensure that the abuses of this country's systems do not become the historic nooses that we wrap around the necks of brilliant and resilient Black women in order to silence them. As women of color, we too have had #enough. With that, we will defer to the President of the Henrico County NAACP, Mr. Frank Thornton.
Good afternoon. At this time, I'd like to give some additional contextual information with regards to the matter that happened at Colonial Trail Elementary. It was not a trespassing situation, okay? These advocates who were going in vigorously to advocate for this family, who at the time was protected under McKinney-Vento and also IDEA was there for bona fide reasons to serve that family's need, and tried to work with that particular administration to collaborate to find a feasible, beneficial outcome to the child's educational experience. During that process, we learned that several violations had taken place prior to the advocates coming on the site to advocate for the child, particularly with the McKinney-Vento matter. As a result, this process was turned into a legal process, unfortunately, where unfortunately the Henrico County Police Department, through the SROs, was used as an agent to manipulate and make these advocates enemies of Henrico County and criminalize them in a manner that was unfortunate and unethical. So, as a result, there are many things that transpired prior to the adjudication of the first case, which was, again, a wrongful conviction of these advocates who were there for the benefit of the child. And in that instance, there were several mischaracterizations that happened in that proceeding. We feel that other than witness testimony which is inconsistent with documentation that has been received, that was not allowed to be produced by the defendants, which is significant. Okay, we have the transcripts that show that one of the police officers testified in that instance as well, misrepresented the statements, and that needs to be looked at very carefully. So this time, we're calling for an overall investigation of all authorities that can look into this matter to make sure that fidelity is added back to the system with regards to justice. So at this time, I'm going to read part of the press release that was rendered out to the media today, so they would be aware of this, because we're moving forward to protect this family and these advocates, to make sure that they have the ability to be citizens and enjoy all the rights afforded to them by the Constitution. So, in the beginning of this reading of this press release, it is appalling when institutions that we trust are weaponized to serve the interest of a leadership team that has resorted to institutional thinking and the demonizing of assertive advocacy. The Henrico County Public Schools has manipulated the abuse of government by calling police officials for non-criminal matters, which is a detriment to the trust of citizens and, in addition, the mismanagement of taxpayer dollars. On January 30th and 31st, the abuse of HCPS was illuminated by its coordinated efforts to criminalize and dehumanize the parent and advocates while conducting federally protected activities. We're here today to bring sunshine on the matter and call for all investigative authorities to research the matter and to bring the proper outcome with regard to accountability. And no time in the history of HCPS has there been an effort to criminalize parents and advocates in the age of collaboration. To this extent, since the era of massive resistance. There's a grave concern about the concerted actions of the Henrico County Public Schools, the Commonwealth Attorney's Office, General District Judge Steverson, and Henrico County Police Officer Sergeant Crook. We really need this looked into immediately. On April 26, Officer Crook offered testimony that was accepted by the judge that needs to be examined for its fidelity. We're calling for the wrongful conviction for trespassing of Tony Hunter Davis, the parent, and advocates Candace Lucas and Dr. Marla Crawford to be overturned. The Henrico NAACP supports these families and these advocates, and we want to make sure they receive true justice in this court.
If there are no questions, thank you.
We have a comment from a parent, Miss Amy Wentz. She wants to clarify that she thought that Henrico fell under the McKinney-Vento as well.
They do.
They do.
Amy is an activist with the Richmond City.